Support comes from Mosby Building Arts, designing custom decks for outdoor relaxation and entertaining. Details at callmosby.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Missouri has a new Attorney General. Catherine Hanaway replaces Andrew Bailey. Will she represent a big change? And a protester charged with assaulting a police officer at Washington University has a novel argument. WashU's campus police, his lawyers say, aren't actually police. Does his argument put this prosecution in peril? And former KMOV meteorologist Megan Danahy won big after taking her station to trial. How was she able to prove discrimination? Those are big questions that require legal expertise to answer, and so we're lucky that today is our legal roundtable. We have 3 top attorneys here with us, and they're willing to shed light on everything that is happening in the St. Louis area judicial system. And today, that includes Arindam Kaur. He's a shareholder at Polsinelli and chair of the firm's National Antitrust Practice Group. He focuses on compliance, counseling, government investigations, and mergers and acquisitions. He also provides outside general counsel services to higher education institutions and emerging entities, and he regularly handles pro bono immigration matters. Arindam, welcome back.
Thank you.
And today we're also joined by Erin Luker. She is an attorney at Sadeh Harper Westhoff. She was previously a public defender for St. Louis County and a prosecuting attorney for the state of Missouri. And prior to joining Sadeh Harper Westhoff, she specialized in special victims cases, crimes against children, domestic violence, and sexual offenses. Now she focuses on employment law, specifically hostile work environments. Erin, welcome back.
Thank you.
And last but never least, this month we are joined by a founding member of the Legal Roundtable. That is Bill Freivogel. He's an attorney and a professor of journalism at Southern Illinois University, Carbondale. Bill, welcome back.
Hi.
So, Bill, I got to start with you today. We have a new attorney general. Catherine Hanaway may actually be the first attorney general of the state of Missouri who's also been a panelist on this Legal Roundtable. You know the full sweep of this show. She's the only one so far, right?
I think so.
Yeah. She is very good on this show. It makes me root for her as an attorney general. But I want to talk just a bit about the man who's leaving us, Andrew Bailey. He is heading to D.C. If he's not already there, he's going to become co-deputy director of the FBI. He was not in this job that long in Missouri. What do you consider to be his legacy here?
Well, he did have some successes. He also had a lot of failures. Among the successes were he was successful in suing to stop President Biden's student loan forgiveness. He, along with some other Republican politicians like Josh Hawley, put pressure on Washington University to close their transgender clinic. He also, something to be said for him is that he ran a 400-person office. He's got administrative experience, something that the 2 people he's joining at the FBI, Kash Patel and Dan Bongino, do not have. And he could, taking on the same sort of title as Dan Bongino, he could be sort of, Bongino could be leaving pretty soon.
This might be the way of easing out this former podcaster. Yeah. I saw a headline coming out of D.C. where they said Andrew Bailey was hired to be his babysitter. Okay, right. It goes from running a 400-person office to babysitting a co-director of the FBI.
One other thing I left out as an accomplishment, which I'm sure he would think was an accomplishment, was forcing out Kim Gardner as circuit attorney in St. Louis.
Yeah, that certainly had a big impact on how justice is served in the city of St. Louis. And yet, Arindam, it feels like there's not too many city voters who are too sad to see Andrew Bailey go. Do you think they should be careful what they wish for when it comes to Catherine Hanaway?
No. I mean, listen, I think Catherine Hanaway has a remarkable record of public service. I think it'll be interesting to see her trying to balance the highly politicized nature of the office and her track record in civil service as well as private practice. I think what I'm really excited about, which I think not only St. Louisans but Missourians should be hopefully excited about, is at least the inclination is that she is truly authentically interested in being the Missouri Attorney General, and not only this term but perhaps a term afterward. And that's just something that I think has been really challenging for this state, not to have a sustainable presence in Jeff City who's looking at and looking out for Missourians. In my compliance trainings, when I talk to clients, I always say, watch out for the feds on certain things, watch out for plaintiffs' lawyers, and watch out for the AG. And I say AG means aspiring governor, because that's usually where AGs would go, right? They would go for state office. But clearly, Missouri has been a launching pad for U.S. Senator, apparently the FBI now. So that's maybe the other legacy that Bailey has. Like, this is a great place to go start your career. But I do think, and I'm hopeful, that Catherine Hanaway will really be focused on the state of Missouri and providing that service that we all deserve from that office.
Yeah, I mean, if we look at the two past people to hold this office, Josh Hawley, Eric Schmidt, they both very rapidly became senators. This seems like a good place to get the attention of voters, to get the attention of the kind of people who could nominate you and propel you. And yet it feels like historically that's not what the Attorney General's office was meant to be. Aaron, you used to work there. What do you think led to this change of the Attorney General's position being such a rapid stepping stone?
Certainly that position in Missouri has become highly politicized in the last several years here in Missouri. I think what is going to be interesting about Catherine Hanaway is even last month, as a defense attorney in defending the Greenbelt Expressway lawsuit, she stated that she seeks to end the presumably Attorney General's unlawful and politically motivated investigation against the Greenbelt Expressway. So she recognizes that there may be some, and has been some, politically motivated lawsuits filed by the Attorney General's office. And maybe in this new position, from her experience as a defense attorney, she's going to turn into a different direction.
That's an interesting theory there, because obviously she's made clear that she probably wants to run for re-election in a couple of years. She has in the past run for statewide office. That's one thing she hasn't been able to do. And yet at the same time, as you say, she does have that perspective of representing people who are fighting the Attorney General's office. I'm glad you brought up the Grain Belt Express, because that is such a high-profile client that she was personally sort of taking the lead on, and they are still locked in litigation with the Attorney General's office. So how does that shake out? I know she addressed this at her press conference with Governor Kehoe. She said, the team that is there, the great team that is there, will be able to go forward without my input. There's a great team on it, and they'll continue to do their work, sort of implying the Attorney General's office is going to continue to push this case against her client. Can they do that?
So there's a lot of issues surrounding her accepting this position into the Attorney General's office while having formerly represented Greenbelt Expressway. For those of you who aren't up to date on all litigation involving the Greenbelt Expressway, Andrew Bailey, using the AG's civil investigative demand, compelled GBE to provide documents related to the company's job creation promises regarding their projects here in Missouri. Their projects in Missouri can be up to $1 billion, if not more, here. And so he launched this investigation under the Missouri Merchandising Practices Act, and Hanaway litigated against those demands by Bailey's office, and in fact filed a lawsuit on behalf of Greenbelt Expressway just last month, asking for the court to set aside this demand. So what's most interesting, though, is that she said she's going to enact a screening process. She won't be involved in that. However, the Missouri Supreme Court rules say that she has a duty to not represent this new client, which is the state of Missouri, in anything that is the same or substantially related matter that was previously that she previously represented them in. So that's Missouri Supreme Court Rule 4-1.9. And among that, following it, is Missouri Rule 4.1.1, 1.10, which says that any lawyers within the firm, including a government organization, are prohibited from representing a case for 1.9. So what they're saying is that she's barred from representing the state of Missouri in actions against Grain Belt Expressway, which are same or substantially the same that she's already been involved in, and the entire government is banned from doing it under the same ethical rules.
So this knocks out the entire Attorney General's office, is how you're reading this.
It does. So we actually have an Office of Legal Ethics Counsel and an advisory committee for the Supreme Court that provides guidance on these rules. So when there's nuances, when we're unsure, can a screening actually take place? And they've addressed this on multiple occasions. In 2005, they said that erecting an ethical screening wall can maybe persuade a former client to waive a conflict, but it doesn't eliminate the conflict under the Missouri rules. And so the entire firm or government must withdraw from the case unless the opposing party consents.
Wow. So Grain Belt Express would have to consent to saying, oh, the AG can continue to bring this case against us. Arindam, I know you're not representing Grain Belt Express here, but it feels like they might have good cause to say, no, we're not going to waive that. We're saying the whole state is kicked off this case.
Yeah, I mean, I think it'll be interesting to see how they handle it and how the firm handles it. And Aaron, I would defer to you whether there's an opportunity for like a special counsel to be appointed to continue the litigation. So I think there are ways that this could happen, but certainly there are some challenges here. But again, these are things that we're seeing, unfortunately, time and again. I think we saw that with Ed Martin as U.S. attorney, and albeit not in Missouri, but representing one of the January rioters and then being in the USA's office in D.C. and dismissing those cases. So
yeah, that seems like a huge conflict.
Yeah. So unfortunately, these are ethical challenges that do come up, and we'll just have to see how this one plays out.
Aaron, Arindam raised the specter of a special counsel. Is that something that could be ethically done here?
So unfortunately, the Missouri Attorney General does not have independent legislative authority to unilaterally appoint special counsel for civil investigations. They have that authority in criminal investigations, but not in civil.
And this is a civil case
And
here.
this is a civil case. So they would actually have to have appointment of special counsel through court approval or through the governor's office, but they would not have a say in who is appointed.
Oh, wow. Bill, what do you think? I mean, is Aaron raising something here that this could become a really sticky wicket for the state of Missouri in its attempt to block this project?
Yeah, I think it's a really good point, but I sort of guess that they will find a way around it through an outside counsel or a special counsel of some sort. So I think there's a way around it.
This feels like a priority of President Trump's, that he wants this thing blocked. Andrew Bailey, sought to make that happen. So you think they're going to find a way to make this thing go forward, even if those of us on this show are saying, hey, wait a minute, there's some ethical rules here.
Yeah, I do think so.
Okay, let's talk about a different prosecution that Andrew Bailey brought near the very end of his tenure running this office. Another high-profile one. This is County Executive Sam Page. Bailey's office charged him with 4 counts, including 2 counts of felony stealing, for using county funds to send a postcard to voters. Page said it was for an educational campaign to let people know about an upcoming ballot measure. The Attorney General says it crossed the line into advocacy, and that makes it illegal. Do you think Catherine Hanaway could approach this case in a different way than Andrew Bailey did?
Well, I think it's possible. I mean, I think it's a very weak case because it appears as though public officials have done what Sam Page did many times and Tom Sullivan, the watchdog, University City watchdog, has complained about it many times, and there haven't been previous prosecutions. Although, I hasten to add that I'm old enough to remember when Bill Webster, the Republican Attorney General, used a copying machine and was prosecuted for that. And that actually wrecked his campaign for governor.
Yeah.
We were talking earlier about Jeff Smith being another sort of borderline kind of prosecution. So
involving a postcard. I feel like the moral of the story is stay away from postcards.
Right. Save a tree.
Yeah, don't send that mailing. But yeah, so you see this as a weak prosecution. Do you think Catherine Hanaway is going to see it the same way, look for an excuse to get rid of what could be a dog of a case? Or is this going to be just as big of a fight for Sam Page's lawyers?
I don't know. I mean, I do think Catherine Hanaway, our former legal roundtable colleague, I do think that she is more professional, and I would very much hesitate to call her more moderate because I wouldn't want to kill her future in the Republican Party. But I was talking to Mike Wolf this morning about her. And
you should say the former Supreme Court judge.
And a Democrat. And he said to me, well, she's sure better than the last two, which was sort of weak
Damning
praise.
with faint praise right there. Yeah.
But I could see her looking seriously at the legal issues there and finding there's not much there as far as showing that Page exceeded his powers and had criminal intent.
Aaron, I'm curious about your perspective as somebody who was a prosecutor. Do you think these felony stealing charges in particular, I understand there's also some election law complaints, but these felony stealing charges, do you see the elements that are necessary to make this case?
Well, I think that's going to be difficult. And part of the reason all stealings by deceit are difficult is because it requires proving a subjective element. Deceit requires proving that the defendant purposely made a false representation and that the defendant did not believe the representation to be true and that the victim relied on that representation. So you have to get into the mindset of the person who is allegedly stealing by deceit and prove either directly or through circumstantial evidence, that intention to purposely provide those false representations. Now, obviously, we haven't been privileged to the evidence and information in this case, but it generally is a difficult type of crime to prosecute because of that subjective element.
Rendon, what do you make of this case involving Sam Page and what Catherine Hanaway may bring to it?
Yeah, my thought is that she will continue the litigation. Part of the challenge, and Bill was sort of alluding to this, she has a term until, 2027, 2028 to finish out this term. To the extent she wants to run again, she's going to have some bona fides that are quasi-political, right? And so this is a case that's already in play.
A few Democratic scalps would be the idea.
Yeah, something, because, if you go back to the prior election, Andrew Bailey, my thought was, during the primary, he had to out-MAGA Will Scharf, right?
Will Scharf, who's now working for Donald Trump in D.C.?
Right. And so she's likely going to have similar challenges if she's going to run for election and there's a primary. This is one case that's already there. I think by litigating it, it shows that her interest is there. But I think what's going to, again, my speculation or guess here, Page is represented by Jeff Jensen, another former U.S. attorney, former FBI agent, former partner at Hush.
Which was the firm Catherine Hanaway was at up until a minute ago.
Yeah, multiple overlaps. I think Jensen was her executive attorney at the U.S. Attorney's Office. So they were connected there. And then I don't think Catherine was managing partner at the time, but at least certainly was hired into her department at Hush. So there's some connections there. And I think this goes for all lawyers. A lot of this is about the level of respect and collegiality that you have even with opposing counsel. These two know each other. Mm-hmm. Could something be hammered out? Could there be some sort of settlement where Catherine can point to, hey, I prosecuted this and got it, absent sort of a full resignation or a trial? Does it weaken Page? I'll let the political roundtable figure that out. But those are the things. So I think that's something she could potentially point to with the continuation of the litigation.
We're talking today to our legal roundtable, not the political roundtable, but man, these things often intersect. That is Arindam Kaur, who is at Polsinelli. We're also joined by Aaron Luker of Sadeh Harper Westhoff and Bill Freivogel. If you have a question or comment for our panel related to what we're talking about today, you can give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air. We're going to take a short break here. When we come back, we actually have even more to talk about involving Andrew Bailey. This is St. Louis on the Air on St. Louis Public Radio.
This is St. Louis Public Radio. Support comes from Perrick Corporation. With a commitment to serving the St. Louis community through local partnerships and charitable support, guided by Perrick's core values. More at perrick.com/culture.
Welcome back. I'm Sarah Fensky. I'm here because today is our legal roundtable. Every month we convene some of the top legal minds in the St. Louis area and really dig into what's going on around town. A lot to talk about this month. I do want to just break here for a moment with some breaking news coverage before we get back to that legal discussion. I know this is something that everyone in America needs to hear right now. Apparently Taylor Swift and Travis Kelce have just announced that they're engaged. So now that we've handled that breaking news bulletin, we can get back to talking about the law. And I'm sure everyone is waiting on the edge of their seat for this legal discussion. We're joined today by Bill Freivogel, an attorney and professor of journalism at Southern Illinois University, Carbondale. We're also joined by Aaron Luker, an attorney at Sadeh Harper Westhoff, former public defender and also former prosecuting attorney for the state of Missouri, now focuses on employment law. And last but not least, Arindam Kaur, a shareholder at Polsinelli. He's currently the chair of the firm's National Antitrust Practice Group. And he provides a lot of other services as well, including pro bono representation on immigration matters. So as we've been talking about Attorney General Andrew Bailey, he had a very interesting case that drew some discussion on last month's legal roundtable. So voters had placed the right to abortion into the state constitution last year. Planned Parenthood, of course, sued over the laws that were then blocking that after voters had approved that. Judge Jerry Jung in Kansas City issued an injunction allowing abortions to resume, and Andrew Bailey appealed that decision to the Missouri Supreme Court. So as we talked about on this roundtable, Andrew Bailey was he was trying to take this directly to the Supreme Court, skipping the appellate court. Our panelist, Dave Rowland, said there was a really important question here that had nothing to do with abortion. The question was whether the Attorney General's office got a fast track to the state Supreme Court for what are called interlocutory appeals. Dave said this was a bellwether case, the first time it had ever been tested. Aaron, how did that go?
Not well. Not well for the Attorney General's office. So Missouri legislation amended Section 526 to authorize the AG to appeal preliminary injunctions straight up to the Missouri Supreme Court. So Andrew Bailey's office was relying on this new statute to bypass the other appellate districts and to go straight to the Supreme Court. Interestingly, in a 7-0 decision, the Supreme Court said, no, thank you, hard pass. Specifically, they said a statute cannot expand this court's exclusive jurisdiction over appeals as established by the Missouri Constitution. And the Missouri Constitution requires that the Supreme Court have a constitutional issue brought before them in order to be bypassed or to go straight to them. And so what they said is preliminary injunction does not have a question, or at least this specific preliminary injunction did not have a question that involved a constitutional issue, and whether or not the legislation amends a section doesn't mean that it changes the Constitution.
Ooh, so 7-0. Arindam, should we read anything into the fact that this was unanimous?
I think these days, whenever you do get a unanimous decision, it adds an added emphasis to the opinion. I think, as Aaron mentioned, I think this case was one that, as mentioned by some of your prior panelists, probably an important case, but one that certainly makes sense in my mind in terms of interpreting the statute and how what goes up to the Supreme Court.
So I want to give credit to panelist Sarah Swadish, who was here this last month. She compared what the Attorney General wanted to do to a fast pass at Disney. She said, quote, "My gut says they're going to swat it down. They don't want every time the AG is clutching his pearls to be running straight to their courthouse." Bill, she got this one right.
She did. And I think they not only sent a message to the now departed AG, but they also sent a message to the legislature. I mean, the legislature basically tried to pave the way for Andrew Bailey to do this. And the court said, you legislature can't change our exclusive jurisdiction as it's set out in the Constitution, because it was pretty clear they were trying to, by doing that, get a different result on the merits. And, one other thing that the court said was that even though there is a constitutional issue down the road, that because it's just a preliminary injunction, there isn't a firm decision on the merits of that constitutional issue. If there had been a firm decision in the lower court saying that these various Missouri abortion laws were unconstitutional because they violated what the voters did, then it could have gone possibly to the Supreme Court.
But instead what we had here was Judge Young saying, hey, I'm likely to say that this is unconstitutional. I'm going to pause this going into effect. But that's a different thing.
That's a different thing. Planned Parenthood is likely to succeed, but I'm not saying that they've succeeded.
Erin?
What I find most exciting about this opinion, though, is this idea that a statute cannot expand or change what the Constitution already establishes. Because underlying that case is the constitutional amendment that voters approved last year, legalizing abortion up until the point of fetal viability. And what the court may be signaling is that is a constitutional amendment that cannot be legislated away in statute. It's not the first time that the court has found this also. Another example, when I was a prosecuting attorney, is that there was legislation passed allowing propensity evidence involving crimes against children and sexual offenders. However, it was slapped down by higher courts until there was a constitutional provision made. And at that point, the court said it's a constitutional provision. We're going to follow this.
So this could have repercussions even beyond the sorts of things lawyers care about.
Absolutely.
Arindam?
Yeah, no, I think we'll continue to see, this being molded, given that this was the first real case regarding this issue. But I think the larger takeaway is it's a positive statement as it relates to checks and balances and the will of voters, things that we, I think, generally all care about. This isn't the end all, but it's certainly an imprint in favor of those things that many of us hold true.
Well, that's some hopeful news. We don't always get that these days. Let's dig into another matter that has me very intrigued. Here's the question. Are Washington University police officers actually law enforcement officers? That question may sound a little bit pedantic, but it could have big repercussions for the county's efforts to prosecute anti-war protesters. St. Louis County prosecuting attorney Melissa Price Smith filed charges against 2 protesters for allegedly assaulting campus police officers at a protest in April of 2024. One of the people charged is Green Party presidential candidate Jill Stein. The other is a grad student, and this grad student is represented by Brendan Roediger. Brendan filed a motion illuminating what he sees as a big problem with these cases, namely that the victims have to be law enforcement officers, but the campus police don't qualify, at least under the university's past arguments in court. Bill, do you think Brendan has found a pretty good gotcha here? He's pointing up their own appellate court filing saying, they said these are not law enforcement officers.
Yeah, I do think he has a good argument. Brendan's a sharp lawyer, and the university has taken this position in other cases when it's in their to their benefit. So they're sort of stuck with their interpretation, their legal interpretation, I think.
And does it work that way? You can quote from somebody's brief filed in a completely unrelated civil suit, and you can be like, here's what they're saying here. They are held to this.
Well, I think it's persuasive. I mean, there's something called the law of the case, and this isn't the same case, so it wouldn't be that. But I think it could be it makes it harder for WashU, for sure.
So I got to interview Brendan about this case in my day job at St. Louis Magazine. He gave me this great quote. He said, quote, under the criminal code, if you're going to charge resisting arrest or you're going to charge someone with assaulting a law enforcement officer, you have to have a law enforcement officer. So that's all easy. Meaning I don't think that any lawyer you talk to who got their mind around this would disagree with me. I told him, well, I have this legal roundtable. I'm going to put you to the test on this. Do we have any takers? Is there anyone who will disagree with Brendan in his sort of very simple explanation of this case? Erin, I see maybe you're willing to take this on.
I think that the problem is that he may not be heard until there's a jury trial or until there's a bench trial. The problem with the argument that they're not law enforcement officers is that goes to the weight of the evidence that the state may have to prove, or to the defenses that he has and to the weight of evidence. So he has a lot of conflicting documents or documents that show that they're not considered police by WashU, and the prosecutors may have a different take on it and be allowed to present that. When you're charged with a crime in Missouri, and I think Sam Page is going to experience the same thing, which is there's very few ways to get those dismissed with prejudice. And if a court dismisses it without prejudice, the prosecutors can refile it over and over again without being accused of vindictive prosecution in a lot of cases. And so the way to get a case dismissed with prejudice is to have a constitutional violation like speedy trial, a double jeopardy, procedural misconduct. None of those go towards the facts of the case per se. And the facts he's alleging here that dispute the indictment are facts he's going to have to prove.
So this is something a judge or judges tend to want juries to decide. Like, I, as a jurist, need to hear this evidence and decide whether I think WashU officers are police officers versus a judge kicking the case out before it even gets to that point.
Absolutely. When it's a question of fact, we leave it to the fact finders, whether that's the court in a bench trial or a jury in a jury trial.
So Brendan might be right, but this is not something we're going to know just based on a motion to dismiss.
And a court can take his motion to dismiss up, but they can defer ruling until after evidence is presented at trial.
See, that's where I always get stuck. That to me seems so dumb. Like, why are you making me sit on a jury and make me decide what the law is when I have no idea what I'm talking about and some judge is later going to tell me I'm wrong? Can somebody explain why I shouldn't get agitated about this? Arindam, calm me down here.
It's part of your civic duty. Come on.
I just got called for jury duty, so this is all very close to the skin for me.
Yes.
But yeah. So that's how this is supposed to work? The court can just wait to decide this motion to dismiss.
The court could wait. I mean, the unfortunate thing here is, these folks were charged in the heat of the moment, right after the protest. Things have, I think, cooled down a little bit. And this has already been juggled, right? Thanks to our lovely, this part of WashU's in the city and this part's in the county. Who's really going to do this prosecution? Again, I'll defer to our prosecutorial experts here, but man, this is a case that they should just kind of let's just get rid of it.
It is interesting we're thinking about talking about a special prosecutor for a misdemeanor. That feels somewhat unusual to me, Bill.
Yes, it does. Maybe we should just leave it to the surveyors to figure out where there's that line between the county.
I'm sure they're going to make me as a jurist sit there and try to figure it out. And
Field trip to WashU
yes,
to find the line.
I don't want to be on that case. Yeah. All right, we are talking to our legal roundtable today, and sure enough, they came through disputing what a lawyer thought was indisputable. That is why I love this group. We're joined today by attorney Bill Freivogel. We're also joined by Arindam Kaur of Polsinelli and Aaron Luker of Sadeh Harper Westhoff. Need to take a quick break. When we come back, we're going to talk about a former KMOV meteorologist who just won big in court. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky. I'm here because it's the last week of the month. Every month we convene the Legal Roundtable so that we can get to the bottom of things or at least air dissenting opinions about things. It's always a great time. And this month we're joined by Arindam Kaur. He's a shareholder at Polsinelli. He's chair of the firm's National Antitrust Practice Group. He also provides outside general counsel services to higher education institutions and emerging entities. We're also joined today by Aaron Luker. She's an attorney at Sadeh Harper Westhoff, former public defender, former prosecuting attorney for the state of Missouri, and now focuses on employment law, which we are going to get to in a moment here. And we're also joined by Bill Freivogel, an attorney and professor of journalism at Southern Illinois University, Carbondale. So, speaking of employment law, former KMOV anchor Megan Danahy, or actually meteorologist, I just misspoke there. The former meteorologist recently won her lawsuit against her former employer. Danahy had sued the station's then news director, Scott Diener, as well as the station itself, saying they discriminated against her because she is female, and then they retaliated when she complained. In a bench trial, Judge Annette Llewellyn awarded her $826,000. Now, a jury had previously found that Diener did not discriminate against her. This ended up being split into two cases, two separate trials. Arindam, that feels very unusual to me, that you'd end up in a situation where you'd have two separate trials that have to deal with the same fact pattern. Is that just ignorance on my part? This happens a lot?
No, I mean, cases can be bifurcated, whether it's for damages and for a number of issues. On this one, one of the toughest things as a litigator, which is why I call myself a recovering litigator, because I don't like doing it anymore, but is making that determination of, is this a case where the jury is going to be an asset? Because once you give it to, a bunch of your peers, you lose control of sort of what's going to happen, right? And that's the biggest challenge here. So does something cater better to a jury? Having a person that you're pointing to for discrimination might work better in a jury versus sort of an amorphous entity that has
the corporation.
Yeah, corporation with some concrete legal arguments where you would want the expertise of the judge to be able to opine on that. So certainly the jury trial with the individual didn't work out for the plaintiff here, but the bench trial against the company did.
Yeah, the bench trial sure did. Aaron, as somebody who deals with these types of cases, are you surprised to see such a dichotomy in how these two cases ended up?
Not at all. So with the jury trial, the issues before the jury in that case were much different than the issues before the judge in her most recent case. In the jury trial, this was for an intentional infliction of emotional distress, which has a whole different set of elements and requirements in tort law that they would have to prove. Whereas in the bench trial, what they're focused on for that was for gender discrimination and retaliation. The gender discrimination and retaliation do have elements that they have to prove, but they're a little bit less complicated unless there's burden shifting. And that's when a bench trial might come in handy.
So in a case like that, you might actually prefer having a judge hearing it instead of a jury?
Certainly, it could be a benefit. So the burden shifts after the plaintiff demonstrates that all the elements of sex discrimination and retaliation have been met. In this case, the plaintiff was represented by Jerry Dobson and John Burns, fantastic employment discrimination attorneys. So they were able to prove that there was sex discrimination and retaliation, and so that then the burden shifts to the defendant, who has to offer evidence of a legitimate, non-discriminatory reason for its actions. Once, if they are able to offer that, the burden shifts back to the plaintiff, where they have to show that this is a pretextual reason. So it may be difficult for a jury to follow a ping-pong back and forth with the burden shifting, especially when you're asking them also to understand and interpret the rules of laws as it's instructed in the jury instructions. And so in this case, a judge who is an expert in the subject matter may be beneficial in following that ball back and forth as the evidence is presented.
Yeah, I'm thinking of myself if I got stuck on one of these trials. Like the burden of proof is shifting. This sounds like exactly the kind of reason that, a judge might be better than a jury here.
Yeah, it does. And I mean, it's having not been in the courtroom, just reading the sort of cold record, I mean, it looks like sex discrimination to me. You suddenly are no longer giving the weekday weather, and that's what everybody wants to do. And then the men are getting that job, and then you're doing the weekend weather instead of the weekday weather. And the men are getting, during COVID, they're getting studios at home, and you're still supposed to come in. You make complaints, and somebody is sending those complaints up the personnel chain to the person who's discriminating against you anyway. So it and you're paid less.
Yeah. Her attorneys did develop a pretty good set of facts here, I must say.
Sounds like sex discrimination to me.
Yeah. It was interesting, Aaron. I'm curious if this makes a difference, but they were able to show all those things that Bill just sort of walked us through. That Megan Danahy didn't get to do this, but her male coworkers did. She didn't get to do this, but this other male coworker got this chance. And there was a second female who was treated the same way as her. And I feel like if I'm reading this as a novel, I'm going, okay, ding, ding, ding. Like, this is where I become convinced that this is sex discrimination, not specific to her as just an individual.
Absolutely. So the law allows plaintiffs' attorneys for employment discrimination case to look into those similarly situated employees. And that can be so important when trying to prove pretext. So the company says, no, we had a legitimate reason to pay you less. We had a legitimate reason to transfer you to a different station. Well, did they do that to the similarly situated employees, or did they not do that to the counterparts to that protected class? When we're talking about race, when we're talking about disability, age, all of those comparators are important in proving that pretextual nature of those decisions.
Something else I thought interesting, which Bill also alluded to, was that Megan Danahy alleged that the HR director of the company was friends with the station's news director, and that HR would sort of swiftly report to him whenever she complained. Arindam, as someone who sometimes does these sort of internal investigations, is that a problem for the company on its face? Could that be a way of just saying, hey, you got to stop treating her this way? She's complaining about this.
I don't know if that would be reflective of best practices. I think when you set up a good compliance training program, that has to be a chain and a channel that can objectively, review and adjudicate these issues and find the way to resolution. And if one of the chain of commands or reporting is the very person that might be at issue here, that compromises the integrity of that compliance piece. It's like having a hotline to report something, but the hotline goes to the boss.
Yeah.
Not helpful.
Bill, as a journalist, I thought it was interesting to read some of this stuff. It was sort of like a little window into how things work in TV news these days.
Yeah, well, it is. And, that one thing that came out in the record was the extent to which the news director at that point was everything was based on ratings. He was talking about the ratings all the time. And I know that's what TV's like. Thank goodness I work for a print newspaper and we didn't have that. Although we did get to a point where we would have people come in and do reader surveys, and the consultants would say, the problem with your story is that, and the Post-Dispatch in general, is that people are spending too much time with it. We have got to make this a paper that people can read faster. And we're sitting there saying, but that's what we thought we wanted people to do.
Bill, I feel like it took the Post-Dispatch a little time, but they've now gotten there.
They've gotten there, yeah.
I should not joke about the state of journalism. Hearing you say they're all obsessed with ratings, I think now everybody's just obsessed with web traffic, and so we're all in the same. We're all in the same boat. Let's talk about a Kansas City-based attorney. He's filed a flurry of lawsuits against St. Louis businesses. That includes many local restaurants. He says their websites are not accessible to blind people. And that, says attorney Kevin Puckett, means they violate the Americans with Disabilities Act. Now, Puckett has the same client in all of these lawsuits. And there have been, at last count, I think we were close to 90 of these lawsuits. His client is a blind man who lives outside of Kansas City, suffers from macular degeneration. He says he was perusing these websites because he was interested in potentially visiting. Now, restaurateurs are saying, really? To me, this kind of feels like a shakedown. Arindam, I'd love to hear your thoughts on this. Do they have a point? Like, where's the line between advocacy for a client, advocacy to fix something that's broken, and something that is a quote-unquote shakedown?
Yeah. When as a base level, I'm hopeful that all attorneys, when they bring a case with a client, they're doing it in good faith and they meet their ethical obligations in bringing a case on that. With the larger point of the ADA and the relevant provisions that on which the lawsuits are on, I've had clients that have been sued on this, and it is absolutely, we call these the nuisance lawsuits. They rarely go to trial. It is for some settlement value.
You're just basically paying someone's legal fees, right?
Legal fees, but there are often, in part of that settlement, some sort of corrective action to comply with the ADA. The ADA was put in place to help with public accommodation. And it especially with websites and other access points, there's relevant language and provisions there. And so, are there gaps there? Certainly. Would it be great that small businesses could have resources where they could work together, or through a trade group where they could work on compliance? That would be great. Absent that, or in scenarios where there is actual an impediment to access, there is a legitimate reason to the ADA has the ability for private action, because the government can't always monitor these things. So I think there are vehicles here where there are legitimate reasons and legitimate ways to impact change that could benefit folks under this provision. Are there issues and times where there's someone who's making a buck off that? Unfortunately, yeah, there probably is.
Yeah. Lawyers wouldn't be incentivized to bring these cases if there wasn't a way to get these fees. Right. Bill, what do you make of this one?
Well, I think the lawyer, I think his name's Puckett, said, in his, written responses, he pointed out that the government isn't doing anything to fix the situation. So it is a private, you have to rely on private lawsuits. I noticed that the Kansas passed a law to make it harder to do these sue and settle cases. And that just struck me a little bit, because I remembered that the person who got the ADA passed was Bob Dole.
Of Kansas.
Of Kansas.
So I'm glad you brought up this Kansas thing. So this thing that they passed there a couple years ago, it's called the, quote, Act Against Abusive Website Access Litigation. It's specifically looking at blind people suing over websites. Like, that's how many of these there have been across the nation. It allows Kansas businesses accused of ADA non-compliant websites to countersue for abusive litigation. And the presumption is that litigation is abusive if the business tried in good faith to remedy the alleged violation within 30 days of receiving written notice. That feels almost unprecedented to me, the idea that you could countersue. Would that be an effective way to sort of stopping these in their tracks, Erin?
Not in Missouri. So one of these lawsuits went to the Western District Court in the Federal U.S. District Court in Western, and it was Myers versus State 24 Holdings, which was a dispensary. And in that case, the defendant argued that the case should be dismissed as moot because after receiving the demand letter from the attorney, they changed the website to make it more accessible. And the court denied that argument, saying that just because you claim that the website wasn't then in violation doesn't mean it was never in violation. And in that case, the court went on to explain that because the website made special promotions, including the fact that it provided coupons for people who signed up with using their email, as well as to pre-order products, and because both of those things could only be fully actualized through a trip to the store, this counted as a violation for the ADA, and the motion to dismiss was denied.
I know from talking to some folk in Kansas City they got hit with these a couple years ago, and they are sort of looking for some sort of legislative remedy. Bill, do you think something like this Kansas Act that would allow for a countersuing, would that be something to nip this in the bud? Philosophically, I know you're not on board for nipping it in the bud.
Right. It could possibly be of some value, although I think the case that we were just talking about maybe indicates it wouldn't be as effective in Missouri.
Yeah, that a Missouri court might say, whoa, this is not constitutional.
Right.
Okay.
There was federal legislation proposed in 2024 to give a 30-day window for businesses to correct any website as related. It did stall out, but I think that would be another remedy for businesses.
That might make more sense than how Kansas handled it.
Absolutely.
Okay. Well, this is one, I have a feeling there's going to be a lot more of these lawsuits. We're going to see how this plays out. And I don't know, it seems like the Missouri legislature, this seems like the sort of thing they might actually be into, whether they can find some way to do it that will pass legal muster. It just didn't work for their fast pass for Andrew Bailey. So
listen, if they can stick it to Kansas, they may look at it. You never know, right?
There you go. That totally makes sense. Well, I want to thank our legal roundtable for joining us today. We have had such a good panel and so many interesting cases to talk about. And that includes Aaron Luker of Sade Harper Westhoff. Aaron, I felt like you were really in the hot seat a lot today, but you did a great job. So thank you for joining us.
Thank you for having me.
And also, I want to thank Attorney Bill Freivogel, founding member. Thanks for joining us.
Thanks.
And last but not least, Arindam Kaur of Polsinelli. Thank you.
Thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.